All right, we're back on the record.
This is where everything begins. And trust me, it starts heavy. Sean L. Jordan is facing multiple felony charges that could lock him away for up to 25 years. Judge Middleton wastes no time setting the stakes: alleged unlawful imprisonment, strangulation, and aggravated domestic assault. That's not just courtroom drama. That's life-changing time behind bars. Now, here's what makes this case intense. The judge personally knows Sean from high school. Imagine presiding over someone's future when you've seen their past firsthand. It's the perfect storm of personal history and high-stakes justice. This is where you, the viewer, need to lock in. Because the deeper we go, the murkier it gets. Witness testimonies, reluctant victims, legal twists, it's all here. Question for you. If the judge personally knows the defendant, should he recuse himself, or is neutrality possible? Let me know below.
This is file number 231670. People versus Sean L. Jordan. That's you, sir?
Yes, sir.
And I've known you since you were in high school, but I'm identifying you for the record. You're charged with some very serious offenses. It's alleged that on or about August 27th, you did knowingly restrain Jesse Pike to facilitate the commission of assault with strangulation or suffocation, a felony. That unlawful imprisonment charge is punishable by up to 15 years in prison and a fine of up to $20,000. Count 2 is assault with intent to do great bodily harm less than murder by strangulation. You did make an assault upon Jesse Pike by strangulation or suffocation, contrary to the statute. That is a felony punishable by up to 10 years imprisonment and a fine of up to $5,000. Count 3 is aggravated domestic violence that you did inflict upon Jesse Pike, who you had a dating relationship with, a serious or aggravated injury.
Excuse me, I believe there's an amended complaint.
Is there? I just printed this yesterday. We got another one.
The amended complaint was filed a couple of weeks ago.
Well, once again, I didn't scroll down far enough. The same thing happened yesterday, so it's on me. Unlawful imprisonment, assault, great bodily harm. Count 2. Count 3, assault, great bodily harm. Same suffocation. And count 4 is aggravated domestic assault. That's a misdemeanor charged as a fourth habitual offender, making this a mandatory minimum 25-year sentence.
When Judge Middleton spells out the potential 25-year mandatory minimum sentence, the gravity of this case hits like a hammer. This isn't about fines or probation. This is decades behind bars if Sean is convicted. But here's the kicker. Prosecutors offer Sean a deal: plead guilty to reduce charges and avoid the 25-year lockup. Most defendants would jump on it. Sean, he rejects it. Why? Is it confidence in his innocence, or a gamble he thinks he can win? From a legal standpoint, rejecting this deal is risky. With the weight of evidence, testimony, and an aggravated habitual offender charge, juries don't take kindly to domestic violence. Let's pause and ask you, would you take the plea deal to save yourself decades, or risk it all to prove your innocence?
So this is a very significant charge, Mr. Jordan. This is a preliminary examination where it must be established that it's probable cause to believe that a crime was committed and probable cause that you did it. You don't get found guilty or not guilty at this hearing. But if it goes to circuit court and you get convicted, you have to do 25 years in prison, the way this is charged. Mr. David Marvin, the county prosecuting attorney, is here. Mr. Marvin, is there a plea offer?
Give me 1 second. Your Honor, to answer your question, there was an offer. It was count 2 and count 4. Dismiss the remainder, and that does eliminate the mandatory 25-year sentence. That was restated, and now I defer to John Bush.
All right, count 2 is assault with intent to do great bodily harm. Count 4 is aggravated domestic assault. The unlawful imprisonment, the other charge, and the supplemental would be dismissed. Mr. Bush, have you had a chance to discuss that with your client?
I had, that was the same offer that we've had before, Your Honor, and he said no then, and he's also telling me no when he wants to prelim today.
Very well. All right, Mr. Marvin, are you ready to proceed?
I am. I don't often ask for an opening statement, but would the court allow that?
Certainly.
All right. Your Honor, I think we'll do the best we can today. There are a number of ways of getting testimony in situations like this when you've got a victim who's very reluctant. And but I just wanted to let the court know that today I'll be asking questions about the Sean Jordan who acted on the day of this incident, and not the Sean Jordan that Jesse Pike really cares for. And I just wanted to let the court know and remind Jesse Pike of that.
All right.
Prosecutor David Marvin takes an interesting approach here. Instead of hammering Sean immediately, he draws a clear line between Sean Jordan, the boyfriend, and Sean Jordan, the accused. That's a strategic move. It separates who Sean was in the relationship from what Sean allegedly did on August 27th. Why? Because the victim, Jesse Pike, still has feelings for Sean. Marvin knows if he pushes too hard, she could shut down completely. And spoiler alert, that's exactly what happens later. This is one of those delicate balancing acts in domestic violence cases. You need the victim's cooperation, but emotional ties can derail testimony. If you were a prosecutor here, would you go hard on the facts or tread lightly to keep the witness talking? Drop your thoughts.
Mr. Bush, any opening from you?
No, no.
Ms. Pike, would you come up and take the witness stand? Why don't you bring that box of Kleenexes right up with you? Would you please face me and raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
All right, have a seat and state your name, please.
This is where the tension spikes. Jesse Pike, the alleged victim, takes the stand, but from the start, it's clear something's off. She's hesitant, soft-spoken, and avoids direct answers. For prosecutors, this is a nightmare scenario. Without her cooperation, proving Sean's guilt becomes nearly impossible. And this isn't unusual. In domestic violence cases, witnesses often recant, minimize, or refuse to testify entirely. Emotional ties, fear of retaliation, or simply wanting to move on, it's all in play here. Here's where Judge Middleton walks a fine line, ensuring Jesse tells the truth while not further traumatizing her. So, what do you think? Should courts force reluctant victims to testify, or should they be allowed to refuse?
Jesse Anna Pike,
Could you spell your name for us?
Jessey, and then Pike.
ANNA.
Yeah.
All right, I ask you to keep your voice up. Mr. Marvin has some questions for you.
Good afternoon, Jesse. All right, and say it again, because you're going to have to speak very clearly and loudly.
Good afternoon.
All right. Jesse, do you recall August 27th, 2023?
Well, yeah,
Do you know the day?
not exactly like the day of the week.
All right. On or about August 27th of 2023, did you contact law enforcement?
Yeah.
What was that?
Yeah,
Okay. Where were you?
the bedroom.
But where were you? What address?
11:35, Millard Court.
And Three Rivers?
Yes.
All right, and that's in St. Joseph County.
Yes, I'm
Okay.
not from here, so yeah.
All right. So you contacted law enforcement. Would you tell the court, why did you contact law enforcement?
I was frightened and I just wanted,
Could you please?
I was frightened and wanted help, like to get separated.
Okay, so you're calling for help. And why were you calling for help? Just big terms. Why were you calling for help?
Argue.
And arguing with whom? Could you say who?
Sean Jordan,
All right, and do you see him today? And where is he?
sitting right there.
All right, Your Honor, she nodded, may the record reflect, she nodded towards defendant.
It may.
Did law enforcement arrive?
Yes.
What did you tell law enforcement? What happened that day?
I got hurt.
You got hurt? Who hurt you? Your Honor, I would,
Well, let's try another. What time of day was this? Was it dark out?
I don't know,
Do you know what time you called the police?
like around 9, I believe.
All right, why don't you go from there, Mr. Marvin?
Your Honor, could I guess that one thing I could request is that I examine this witness as like cross, I guess, as a hostile. I could treat her as a hostile witness. I'd ask that.
This moment changes everything. Prosecutor Marvin realizes Jessie isn't cooperating, so he asks the court to treat her as a hostile witness. Why does that matter? It gives him more leeway in questioning her. Normally, you can't badger your own witness, but once labeled hostile, you can press harder, challenge contradictions, and even confront them with prior statements. But there's a human cost here. Jessie clearly doesn't want to be here. Her reluctance isn't just discomfort, it's palpable fear mixed with loyalty. This raises a bigger issue. How do you balance a victim's rights with the pursuit of justice? Should prosecutors push harder or back off when someone refuses to cooperate?
Otherwise, I'm afraid this might be a situation where I have to request other testimony in another way. We might have to reschedule it.
All right, well, Mr. Bush, any response?
My client's. Yeah, I'm not satisfied with, we've reached a level that she can be treated as a hostile witness, but I would have no objection to a brief recess if Mr. Marvin wants to talk to her.
All right, well, let's see where we go here. Miss Jordan, Miss Peterson, or excuse me, Miss Pike, let me get it right. You got a subpoena to be here yesterday.
I did not get a speech.
Okay, but did you get a subpoena to be here?
Inadvertently, they had 11:37 Millard Court.
That's what it
That's
says
what-
here.
It's 11:35.
All right. Well, you're here now. Did you come with a subpoena?
No, I came because the police tracked me down at my work.
All right,
This was a verbal agreement to come back today
all right.
after yesterday. She cooperated and was
Well,
good
yeah,
about it.
yesterday we got delayed, so we set this for today. Are you uncomfortable being here?
Yes,
And did you talk to Mr. Marvin about this case?
yeah, yes.
And are you reluctant because you don't want Sean to get in more trouble?
No, I don't want him to get in trouble.
He's in trouble. And he's been charged with these criminal offenses. you have a obligation as you're under oath to answer the questions truthfully. And so I'm going to allow Mr. Marvin to do this as if he were cross-examining you as a reluctant witness.
Thank you, Your Honor. Jesse, is it true you contacted law enforcement for help?
Yes,
And when you got there, is it true you had injuries?
to my eye.
All right, so you had an eye injury. How did you receive the eye injury?
All right, just a minute. Can you answer that? How did you receive the eye injury?
Jessie flat out refuses to answer certain questions about her injuries. At one point, she even shakes her head silently instead of speaking. Judge Middleton steps in, reminding her she's under oath and that refusing to testify could put her in contempt of court. From a legal perspective, this is a tightrope walk. On one side, the court needs her testimony to establish probable cause. On the other, forcing her answers risks re-traumatizing her and making the witness completely uncooperative. This is where the stakes get real. Jessie risks legal penalties for protecting Sean, while Sean faces decades if she talks. Let me throw this to you. If you were in Jessie's shoes, torn between loyalty and self-preservation, what would you do?
The record can't reflect she's shaking her head no, Your Honor.
Are you unwilling to answer the question?
I don't want to answer.
Your Honor, may I ask a series of yes or no?
Let me explore this a little further. I don't want to answer isn't a sufficient answer. People are often here and they have to answer something they don't want to do, but you're here pursuant to a court order and you're under oath in a capital case. So the fact that you don't want to answer the question doesn't mean you don't have to answer it truthfully. So you indicated that you were injured. Can you tell Mr. Marvin how you got the injury?
During the argument, I don't know exactly what happened. I was kind of flailing around. I don't know exactly what happened.
All right, Mr. Marvin, you can ask questions.
Where did that injury happen? Where were you? Oh. So you're in the bedroom. Why were you flailing?
Because of the argument, and I was worried and instantly felt like I wanted to get out of there.
Were you not able to get out of there? Jesse, is it true that you were in the kitchen making toast? You bumped the refrigerator door, hit you. You got mad, or Sean got mad because you're in the way and he hit you. You took your toast and you retreated to the bedroom?
Stop. Is that true?
I don't remember being in the kitchen at all.
All right. Your Honor, I don't know how to move forward. I could move forward and treat this victim as though she died that night, and I am afraid that's what I'm going to have to do.
Well, These are very difficult cases. We had 3 this week where they're alleged to be very serious assaultive injuries inflicted by men on women. In each case, the female, the complaining witness, was reluctant to testify. I had a very bad case yesterday where an animal was killed, and I had another case where a woman was badly beaten about the face. And now we have this case. So in each of those 3 cases, the victim was reluctant to.
Judge Middleton pauses the entire proceeding to make a powerful observation. This isn't an isolated case. He's seen 3 domestic violence cases this week alone, where victims refused to testify. One involved a woman beaten so badly her face was unrecognizable. Another case, an animal was killed. The judge lays bare a brutal reality. Our legal system struggles when victims won't cooperate. Without their testimony, prosecutors rely on exceptions, like hearsay rules, to build a case, but it's never as strong. This moment forces us to confront a hard truth. The justice system is built on people telling their stories, but what happens when fear, love, or loyalty silences them? Tell me in the comments, should the system change how it handles domestic violence cases where victims stay silent?
Disclose under oath what had happened. If they were dead, they would not be able to disclose under oath what had happened, which makes the witness unavailable and allows for some hearsay. In domestic violence cases, there are specific hearsay exceptions. I don't have the statute right in front of me. Mr. Marvin, do you happen to know the site for that?
I don't know the site for that. And unfortunately, I'm not prepared because the officer who took the statements while he was here yesterday could not come back today.
All right.
I believe it's something 27B, Your Honor, but I don't know the numbers.
It is 76927B, I think. But it's more expansive than that. 76927B is something different. I don't have it in front of me. Yes, there are exceptions for hearsay.
Seven 6827.
One off.
Yeah, so 76827B and C.
This is where things take a legal detour, and it's fascinating. With Jesse refusing to cooperate, Prosecutor Marvin leans on hearsay exceptions under Section 768.27b. In domestic violence cases, certain prior statements, like what Jesse told police earlier, can be admitted even if she clams up on the stand. Think about the strategy here. Marvin knows his key witness is shutting down, so he pivots. But defense attorneys hate this because hearsay isn't cross-examinable. It risks swaying juries with statements the defense can't fully challenge. This tactic could make or break the case. If those prior statements come in, Sean's in serious trouble. Let's throw this one at you. Should prosecutors rely on hearsay when victims stay silent, or does that cross a fairness line?
Does have a notice requirement, but
Yes.
in a preliminary examination, you can't do the 15 days notice. All right. Let's try to go as far as we can with this witness.
Okay. Jesse, are you ready?
Throw up.
All right. Did the police come?
Yes.
Did you tell them what happened?
Not exactly. I told them that I had hurt myself doing laundry.
Here's where the contradictions explode. Jessie suddenly claims she hurt herself doing laundry. Wait, what? That's not what she allegedly told police. She said Sean strangled her, punched her, and pulled her back into the house when she tried to escape. This is classic recanting behavior. Victims often change their stories out of fear, guilt, or love. But here's the catch. Her prior police statement, the officer's testimony, and even physical evidence could all contradict what she's saying now. For the jury, this is confusing. For the prosecution, it's a disaster, unless they use those earlier statements under hearsay rules. What do you think? Would you trust the laundry accident explanation, or does it sound like Jessie is protecting Sean?
Your Honor,
When they came to the door, that's, you can ask.
All right. I'm going to continue this matter. You're going to have to do it as though she weren't here. You're in contempt of court for failing to answer the questions lawfully. And I'm not sure how to deal with that. We'll deal with that in a minute. You have a subpoena. You're here. You're under oath. You don't have a Fifth Amendment privilege not to testify. You can't just not answer the questions. There can be a sanction for that.
I did answer. That's when the door was open.
All right. So let's see where we can go ahead, Mr. Marvin.
This is where Judge Middleton drops the hammer. Jessie's refusal to answer crosses into dangerous territory, contempt of court. That means fines, potential jail time, and even perjury charges if her answers conflict with prior statements. But let's pause here. Think about the impossible position Jessie is in. Testify against Sean, potentially put him away for 25 years. Protect Sean, risk her own criminal liability. It's a brutal choice. And Middleton knows it. He tries balancing empathy and authority, reminding her of her oath but carefully avoiding aggressive pressure. Question for you: should courts ever jail domestic violence victims for refusing to testify, or should the system prioritize their protection?
Jesse, did you, after an argument in the kitchen, did you go to the bedroom to get away and to de-escalate the situation?
I don't remember being in the kitchen, but I was in the bedroom.
All
I
right.
was laying down.
Okay. How long were you in the bedroom?
15 minutes, 20.
All right. And isn't it true that when interviewed, you told law enforcement that when you tried to leave the bedroom, you were pulled back by your hair?
This moment is chilling. According to her prior statement, Jessie tried to escape through the front door, but Sean allegedly pulled her back into the house by her hair. Over the next 30 minutes, she claims she was punched, held down, and strangled. But in court, Jessie can't or won't confirm any of it. The silence is deafening. You can feel the tension between love, fear, and survival playing out in real time. For prosecutors, this inconsistency forces them to build the case around other evidence: body cam footage, photos, and police testimony. Let me ask you, if physical evidence proves Jessie's injuries, should the case move forward even without her cooperation?
And over the course of 30 minutes, you were punched, held down, and strangled.
Like yesterday when I talked about, there was different instances where things are getting mixed up.
All right, so what I just described Did that not happen in the bedroom?
No,
Where did that happen? In the living room? Okay, all right. Jesse, did you at some point try to escape by exiting the house, the door, the front door of the home? Yes or no?
I tried to go out the door. Yeah,
And-
it was locked.
Okay. And were you pulled away from the door and brought back into the house?
Yeah,
Okay. At any point, Jesse, were you choked or strangled? Jesse, were you choked or strangled?
oh,
Okay. At any point, was your air or your breathing restricted or stopped? Your Honor, I can't continue. It's
Yes, all right.
not accurate, at least with respect to the report and what we talked about yesterday for over an hour.
Yes. Officer Greenhalgh was here, as Mr. Marvin indicated. He had a subpoena for yesterday.
At this point, the prosecution's strategy hits a wall. With Jesse shutting down, Marvin asks to reschedule the hearing so they can bring in the investigating officer and body cam footage. This is smart. Without Jesse's cooperation, the case hinges on secondary evidence. But delays also create risks. Witnesses' memories fade, defense attorneys exploit gaps, and momentum slips away. Judge Middleton agrees to continue the case until October 10th, giving the prosecution time to regroup. But here's the deeper takeaway. This isn't just about one case. It highlights the system-wide struggle in prosecuting domestic violence when victims won't testify. Engage with me here. Should cases like this rely more on technology, like body cam footage, instead of traumatizing victims by forcing them onto the stand?
Through no fault of Mr. Jordan or Mr. Marvin or Mr. Bush, we weren't able to get to this case.
I do have a suggestion, Your Honor.
Yes,
If we move the case, I believe yesterday you set a prelim 2 weeks from yesterday. I would waive the 14-day notice if Mr. Marvin wants to file the 27B notice and we can proceed 2 weeks from yesterday. Just a thought.
all right. I'm going to continue this matter until Tuesday, October 10th. At 1 o'clock. There's already a bunch of stuff on there, but we'll make a priority for this. Does that work for you, Mr. Marvin?
It does. I appreciate the accommodation and I will file my notice appropriately and properly under the statute.
Miss Pike, I know that you're afraid and you're reluctant to be here. And this is a very common and recurring problem. I used to be the prosecutor for a long time before I was judge. And I've seen this problem many times. And even though you're not cooperating with your subpoena,
This is one of the most human moments in the hearing. Judge Middleton speaks directly to Jessie, acknowledging her fear and reluctance. You can sense his frustration, not with her, but with the system itself. He admits something few judges say out loud. The justice system hasn't figured out how to handle situations like this. Punishing victims for staying silent feels wrong, but without their testimony, cases collapse, and alleged abusers walk free. This moment makes you question, is justice about protecting victims or punishing offenders? And what happens when those goals collide? Drop your thoughts. How would you fix this broken dynamic?
Forgot a subpoena.
all right, well, you're here, you're under oath, and you're declining to answer the questions. You did answer, I guess, eventually, although Mr. Marvin feels the answer was not truthful, which places you in a position of potentially being charged with perjury. So the question is, what do you do? Assuming that the allegations are correct and you were beaten and choked and strangled and had your eyes swollen shut, are you then further punished by the court for failing to cooperate? We've been struggling with that the entire time I've been in the system. So, Mr. Marvin, are you going to give her another subpoena for October 10th?
Yes, I am. I'll give that a shot. We'll continue to work and support her the best we can. We've got Marissa and I met with her. Officer Greenhalgh and I met with her. I understand the situation she's in and we care about her, and we'll try on the top.
I have a couple of questions. Are you still at the Millard Court address
Yes,
with Mr. Jordan's father?
no.
Or I thought he
He's
was
in
living.
the nursing.
Okay, so he's not there. Whose house is it?
Bart Trammell.
And you're a renter.
Yeah, he just put my name on the lease.
So your name is on the lease.
Yeah.
Very good.
on the lease, yeah.
All right. Well, I was just concerned if you were going to be there alone with Mr. Jordan's father.
No.
All right. All right, we will continue this for the availability of Officer Greenhalgh, perhaps body cam videos, photographs, anything else, and try to complete the preliminary examination.
Prosecutor Marvin outlines his next move: bring back Officer Greenhalgh's, introduce body cam footage, photos, and other corroborating evidence. It's a solid pivot, but without Jessie, it's still an uphill climb. Meanwhile, Sean remains in custody on a high bond, staring down a potential 25-year minimum. That's the weight hanging over everything: freedom versus decades in prison, love versus truth, silence versus justice. For us watching, this is where suspense peaks. The next hearing could flip this case entirely. Will the evidence be strong enough without Jessie? Will she cooperate next time? What's your prediction? Does Sean walk, or does the evidence bury him?
Mr. Bush proposed the date. Mr. Jordan is in custody in lieu of a very high bond. He is charged with a 25-year mandatory minimum offense. It's apparent that the victim witness is reluctant to testify. So bond will stay where it is, and we're going to try this again on October 10th.
Thank you.
All right, thank you. I'll be in recess.
Thank you, Judge.
Thank you. Miss Pike, you're free to step down once you accompany Mr. Marvin out. Sorry about all the waiting around.
testimony is correct and correct.
I don't think so. Maybe if you could hold on to him for just for a few moments, maybe.
Mr. Jordan, I'll see you next time.
He's talking to her. I'm just gonna sit tight.
All right. Well, that is an age-old problem. Does the victim get punished twice? I don't know the answer. I don't know what happened. I wasn't there. The affidavit is quite powerful. All right. Well, that's as much as we can do today. We'll be back again tomorrow with more stuff.
And that's where today's hearing ends. No resolution, no closure, just a ticking clock until October 10th. Judge Middleton sets the stage for a battle that will hinge on body cam footage, police testimony, and Jesse's next move. Here's what's at stake. If prosecutors secure solid evidence, Sean faces decades behind bars. If Jesse stays silent and the evidence falls short, he could walk free. Either way, this case highlights how domestic violence law collides with human emotion, and the results aren't always clean. If you found this breakdown as shocking as we did, don't just scroll away. Hit like if you want more courtroom deep dives, drop a comment with your take on this case, and subscribe so you never miss another jaw-dropping trial truth analysis.